Well, welcome back to the hot seat. Delighted to be joined today by Jess Miller from Strela Advisory. Good afternoon, Jess.
Hi, how are you doing?
Very well, thanks. So we're working on some webinar content together through the first quarter of this year on unidentified wealth orders, on private wealth disputes, lots of interesting things to come. But you're a relatively new member of PCD, so it'd be great for you to explain a little bit about yourself and your business in case people aren't already familiar.
Sure. So I set up Strela Advisory in late 2017, and we're a boutique investigations firm that really has kind of two areas. So one is dispute support and asset recovery, and then the other side of it is private client. There's a huge amount of synchronicity effectively between those two areas because for the most part, the litigation support work is for disputes between private clients, high net worth individuals, or companies that are effectively an extension of those individuals. Personally, I work a lot with high net worths from the CIS and from the Middle East.
I mean, just coming first to private clients and particularly looking at the reputation management side, I mean, what kind of threats might high net worth families face online and what can they do to help protect themselves?
There are kind of objective risks of the internet, and then you have the ones that are the more idiosyncratic and are defined as a risk by virtue of the client, their ambitions, their existing profile, and sometimes even their cultural background. So objectively, the problem with information going online is how fast it spreads and really how little accountability there is when things are put on the internet versus if something is put out in print press, particularly in the UK, you can have it pulled quite quickly. You can ask the newspapers and get a retraction. You can go to IPSO. You can have an injunction to stop it even getting out there. And they are levers that you don't have online. There are things like right to be forgotten with Google, but then that only applies to the EU. So then if you route your Google through another jurisdiction, you may end up seeing stories that clients have worked so hard to have removed elsewhere. So coming to these kind of like idiosyncratic risks, they are where you have a kind of inadvertent insight that a high net worth individual or their family is giving into their lifestyle or their assets. Some people might not care about this. Others may be a lot more circumspect about their wealth and how they choose to portray it and use various different offshore structures or whatever it is to be discreet and really hold on to their privacy. And that's fine if they have the primary wealth holder is being discreet, not all over Twitter, not all over Instagram, not on Facebook, but you have to view the family as a whole and work with everybody because that's going to come undone if your spouse, girlfriend, boyfriend, children kind of don't get the memo on this. So you have to kind of work with the family overall to raise a little bit about awareness of what you're putting on and what you're not putting on, because as an investigator, these are leads that can be used in an investigation, or journalists may be interested in them, or whoever it is. So yeah, there's idiosyncrasies to risk online.
Well, there's a big education piece there, isn't there? Getting the family at all different generations to buy into the idea that they need to protect privacy, because if they don't, that's where these issues will arise. You will also provide a lot of support to PCD members like lawyers and trustees and professionals who are client facing, and you can support them in the investigations role or during disputes. I mean, how do you typically work with professional advisors dealing with high net worth clients?
So if we're working for the claimant, for example, in a dispute, then it's going to be around things like trying to serve the other side. That's the first and sometimes massive hurdle in getting any proceedings started. And if it's a dispute between high net worth individuals, they are by nature a pretty peripatetic group. And so with no fixed abode, but in the most luxury way. So that can be a difficulty to overcome. Then it will be on the asset tracing and recovery. So finding where individuals hold their assets. It could be anything from homes, other property, business interests, private jets, your yacht, working through the structures that other PCD members spend so much time putting together. And also in kind of analysis really of your own position. So what can happen in disputes where reputation may be used as a lever, or you're trying to understand vulnerabilities, is that the other side may well be investigating you and trying to find out where your sort of soft spots are, and what effectively investigating yourself can help find those before they become a problem. Or if you know that actually going into a litigation, going into a big dispute, which may become public, is not really going to be in your own best interest, then you may want to settle. So that's on the claimant side. On the defendant, it is again around that reputation. And then also looking at the permeability or not really of the structures you have, because can you be tied to asset X or not? So it's flipping it. So doing to yourself what the other side will be doing to you, but in your own best interest.
And do you also work with intermediaries who are looking to do due diligence on potential investors? Is that part of what you can establish in an investigation?
Yes, very much so. Most compliance teams, or pretty much all of them, will have their own databases. And for kind of conventional due diligence, they're incredibly useful. If your only concerns are around, sanctions, exposure, Interpol red notices, other kind of prosecutions, legal issues that your potential client may have had, there are loads of databases that can do that. Where investigators can come in, and particularly boutique investigations firms, is where you can't quite get off the fence and you're basically just sat in a grey zone, not really understanding who you're dealing with. And this can be because a compliance database may not take a story all the way to its conclusion. So you might get something that says individual X got arrested last month, and then the story's dropped, and you don't know where this guy is now. Is he at home or is he in jail? And that's having investigators on the ground figure out the answers to those questions, providing context to any allegations, and providing some conclusions and some context to the kind of things you're seeing is incredibly useful, or can be incredibly useful for compliance teams when, as I say, they can't quite decide either way.
And it brings us, I suppose, to the more broad point of like London just being a magnet for this kind of international wealth.
Yeah.
And part of that attraction, I think, is the court system. There's been a lot, obviously, of cases in commercial arbitration coming through the London courts, but also, private wealth disputes, big ticket divorces, come to London for judgments. What's your perspective on the role of the courts in London, how they have an impact in international private wealth?
English courts are at the forefront of private wealth disputes. And you see this in the diversity of claimant and defendant parties to those disputes in London. The English legal system has kind of set the benchmark in an awful lot of areas, and particularly those that are related to private clients. So issues of libel, obviously kind of contractual breach of contract, those kind of things, trusts and probate contentious, that's heard out in the English courts. There's nothing really quite as scary as an English court issued worldwide freezing order, and they really do stand for something. And it is a testament to our judiciary that a lot of that is because of firstly the impartiality of our judges in hearing cases, and also our legal system is a bit like, it's kind of like an organic organism, and it develops and it evolves. So you can bring cases to London that maybe can't be heard anywhere else, or on a new piece of law, or there's some kind of element to them that's a bit odd or a bit out there, and our courts will hear it, will address it, it will come part of our case law, and so this organism kind of evolves. And I think that's what's so important about the English legal system. I don't really see any kind of competitor emerging in that way. And you know, if you look at divorces in recent years, we've had, you know, Sheikh Mohammed Al Maktoum and Princess Haya, Tatiana and Farhad Akhmedov. This international, I mean, it can't even call Sheikh Mohammed a high net worth individual, a head of state, coming to deal with these hugely sensitive, important family matters, and they're doing it in London.
And I guess that ecosystem then creates the expertise amongst the professionals and very specialised professional services that sit alongside. So whether it's having then the top class litigators who've dealt at that level, you know, it creates its own advantage, doesn't it? Because then the only place to get that expertise is in the true kind of global centres. But I mean, are there any other centres, like, you know, in New York or other parts of the world where there's a similar sense of international kind of justice being served out? Or what's your perspective? Are there other regions coming through that are trying to recreate that same, you know, create the same impact?
No, I think when it comes to international arbitration, we have the LCIA, and there are obviously traditional competitors to it. So you have Paris and Stockholm and Singapore, and financial centres now around the globe developing their own arbitration centres. So you've got, you know, recently set up in Kazakhstan, Dubai, of course. So Moscow set one up. So in arbitration, there is an increasing diversity of forum. But when it comes to private wealth disputes, I don't think there is necessarily a challenger to London. There are other jurisdictions where you will see part of a dispute played out. So that can be in a lot of the offshore jurisdictions where you've got a particular element. The primary focus of or forum for the dispute is going to be London, but then you're looking at enforcement or some kind of disclosure, and for that you will need to go to the BVI, for example, or Jersey if you've got trust held there. So there are ancillary jurisdictions that become incredibly important in private client disputes due to how individuals are holding their assets and structuring their wealth. But as the principal theatre for these disputes, London.
So we're going to do a full session on unidentified wealth orders, which we'll get into the details of the kind of the latest cases and examples of how advisors are dealing with that. But do you think initiatives like that make London less attractive for a global audience, where they feel that by having a footprint in London, there's some kind of a threat or risk to wealth? What's your perspective on how that affects the psychology of investors from, say, Russia or the Middle East, how they view the UK? Or is this just normal course of business? Do they sort of think that that's fine or not? What's your view?
I think every single time a bit of legislation comes out like this, the immediate kickback is, oh my God, what does it mean? What's the implication? What are we going to do about it? We had that with the Bribery Act when this came out, sanctions, 2014, that was a kickback. How are we ever going to do any deals or ever work with anyone from Russia or Ukraine ever again? Oh my God. And then what happens is once everybody concerned, clients themselves, their advisors, decide on legal, become used to it, and in certain cases this legislation is challenged on its application, then it just becomes almost incorporated into working practices. And there are certain things about an unexplained wealth order that make it a little scarier than just going in front of a compliance team and asking for a bank account. But for high net worths trying to move their wealth to London, or in any way establish a presence in the UK, the sort of things that an unidentified wealth order is intended to combat are questions that they will probably have already answered previously. If they're not, they should be doing it. but it is again how you perceive. So the Hajieva unexplained wealth order came off the back of, I believe, reporting in Azerbaijan about her proposed corruption and that of her husband, and that was the hook, I think, for that unexplained wealth order. If you have good advisors and you're a high net worth, you will have an idea about what is being said about you. Can you challenge it? Can you not? And already the unexplained wealth orders have been challenged by Nurali Aliyev. So it's kind of, 1-1 high net worth NCA when it comes to unexplained wealth orders. So then it's not the end of the world.
And it is part of the way we're going globally, isn't it? So like you say, these questions won't come as a surprise to these global families. I mean, many of the family lawyers that I speak with talk as well about settling disputes behind closed doors to get more privacy from that, rather than taking things through the courts. If you're working with lawyers who are doing mediations, often high stakes, with families that don't want to manage the way that information flows into the public domain, I imagine the role of an investigator there is equally important as if you're going to court or if you're having a behind closed doors settlement. What's your view on helping people through mediation?
The point of mediation is to avoid ending up in litigation, to avoid details making their way into the public domain, and it's conciliatory by nature to try and find an equitable settlement or agreement for both parties. But in any kind of negotiation, you need to sort of understand what does the other side want, or what are they worried about? What are their preoccupations? Where are kind of the levers effectively in that negotiation? Because otherwise, sometimes if you don't understand somebody's motives, maybe then their actions become incomprehensible, and that doesn't work when you're trying to come to a settlement. So some investigation to answer those things, if they are, if one side is sitting in the dark a little bit, is very useful, just informing you so that you can walk into your mediation in the best informed position possible. I mean, that's the point of an investigation ultimately, is to give the client the information that they need to make a decision, to bring about a resolution, and to make sure that they're doing these things from the best informed position possible.
Okay, well, thank you very much for talking to me today, Jess. We look forward to working with you on the upcoming webinars and sharing this with our members.
Brilliant. Thank you so much.